Hello. So today I'll be speaking about the new criminal laws which have been brought in India, doing away with the centuries old criminal laws based on the colonial philosophy. So Indian Parliament has now done away with the Indian Penal Code of 1860, and also the Criminal Procedure Code has been replaced by Bharatiya Nyaya Sanhita and Bharatiya Nagarik Suraksha Sanhita respectively. Similarly, Indian Evidence Act has also been replaced by Bharatiya Sakshya Sanhita. These three new laws have received the presidential assent on 25th of December 2023 and has also been notified in the Gazette and will be effective from 1st of July 2024. So the notable change which have been introduced by the three acts, I'll briefly summarize, and then we will see what effect it will have on the ongoing trials. So the Bharatiya Nyaya Sanhita, which replaces the Indian Penal Code, has first time defined a terrorist act. So any act done by any person which is against the sovereignty and integrity of India has been defined as a terrorist act and which is a punishable offence. Similarly, Raj Droh has been replaced by Desh Droh. So this is like citizens still get a right to criticize the actions of the government. However, if their actions are found to be against the interest of the nation, it has been made a penal offence. Similarly, mob lynching has been introduced as a separate offence. Also, the organized crime has been made an offence, probably drawing inspiration from Makoka of Maharashtra and Gujarat Organized Crime Act. So these are some of the new additions in the new criminal law, and also the punishment for various offences have been increased, like hit and run cases. We all realize that the penalty of 2 years was not sufficient in hit and run cases, so it has now been increased. Similarly, in the procedural law, that is Bharatiya Nagarik Suraksha Sanhita, there are many progressive and notable changes. The most important change is the registration of the zero FIR. We all know that how the police was reluctant to register the FIR on the ground of lack of territorial jurisdiction. So the new Nagarik Sanhita makes it mandatory for the police to register an FIR on receiving the information about any cognizable offence, irrespective of the jurisdiction. So the provision for zero FIR has been made. Secondly, the video recording of the victim statement has been introduced, which is again a very progressive step, keeping in tune with the advancement in the technology, and this is basically with the respect to the sexual offences cases. Also, the provision for bail for the first time offenders, especially when they have served one third of the maximum punishment prescribed for that particular offence, has been introduced, which is a very progressive and welcome feature. Also, the provision for community service has been introduced by the new criminal laws, which is again probably draws inspiration from Sanjeev Nanda case, which is again a very progressive feature, and this is actually prevalent in many of the criminal jurisdictions across the world. So these are the basic changes which have been brought about in penal laws and the procedural laws. Similarly, the Sakshya Adhiniyam of 2023 has also been tweaked in to bring it in tune with the advancement of the technology. So, recording of a statement through electronic mode have been introduced by new Sakshya Adhiniyam. So overall, very good step by the Parliament to remove um, the old laws which were centuries old and were more in the nature of a punitive action rather than restoration based and rehabilitation based criminal laws, which is the which is the philosophical change which is happening across the globe. Now, a very interesting question arises as to what about the criminal trials which are already going on, whether it will be governed by the old law, or will it be governed by the new laws. So it is very important to note here that Article 20 of the Constitution of India prohibits that criminal laws, especially the substantive criminal laws, cannot be given retrospective effect. So, therefore, the provisions of new law will not be applicable in the ongoing trials, and they will still be governed by the Indian Penal Code of 1860. Uh, so far as the procedural law is concerned, it will be interesting to see, because a procedural law can be given a retrospective effect provided it does not put the accused person in any disadvantaged position. So there is a possibility of difference of opinion between different courts with respect to the applicability of procedural laws. However, for the penal laws, or the substantive criminal law, it cannot be given a retrospective effect. So the trial will happen only on the basis of the act that was in force at the time of the commission of the offense. Thank you.